The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. All right, we'll call the first case, which is Walsh versus Winofsky, and Mr. Golombek, we'll hear from you first.
Thank you, Your Honors, and good morning. The district court's decision below hinges on a finding that Adam Winofsky, a business person, not a valuation expert, should have automatically concluded that the price offered for shares of closely held company stock was too high, something that every valuation professional that considered this question disagreed about, including the district court below. Let's take a look at the numbers. The valuation firm involved in the transaction, Capital Advisors, found that the share price was $406 per share. Defense expert found that the share price was $493 a share. The department's own expert found it was $180 a share, and the district court came out somewhere in the middle at $278.50 per share. Now, the Department of Labor contends here that $406 per share is so clearly an inflated price that Mr. Winofsky knew, based on that fact alone, that by accepting it, he'd be violating ERISA. Yeah.
Did he have information about all those assessments? I thought when he came into this transaction, he only had Mr. Napier's numbers before seeing the $406 number.
Right. He had reviewed prior valuation reports, and there's some disagreement at the district court level.
My question is whether he recited all these different valuations. And my question is, did he have those numbers when he entered the transaction?
He did not. He only had the one number, the $406 per share. After 4 years of litigation and with the aid of a valuation expert, the price the department believed that the stock was worth was
Mr. Golombek, can I follow up on, excuse me, Mr. Golombek, Judge Diaz here. Can I follow up on Judge Niemeyer's questions? So he did not have the sort of the post transaction numbers evaluations, but he did have the historical evidence of valuation, which tended to show that at least would have given someone pause as to what the price should have been, because over the course of 4 or 5 years, Mr. Napier had consistently evaluated the price of the company, the shares, at somewhere in the neighborhood of $220 to $285 per share. So why shouldn't that have been? And all of a sudden, then we get a 400 plus valuation right before he sells his remaining portion of the shares. Why wouldn't that have been cause for some concern, or at least some further inquiry?
Well, the Great Recession occurred obviously during this time in 2008, and it affected every company in the country. And by 2009, the company, which had been rising steadily, as you said, an increase of over 30% in the 5-year period before the Great Recession, like every company, it was impacted by it, but there was every reason to believe it was coming out of the recession, and there's evidence to believe that Mr. Winofsky believed that to be the case, as well as others within the company.
I thought it was just the opposite. I thought he said they were looking forward to a tougher year.
That's not the evidence. The evidence shows that he believed that there was a backlog of orders that was going to produce a robust future prospects for the company, as well as efforts to diversify the company. The Department of Labor itself believed that the price, again, after four years of litigation, the department believed that the share price was $180 a share. That's $100 less than what the district court found. So that error is the same magnitude as the amount by which the district court found the stock to be overvalued, just in the opposite direction. So
counsel, let me stop. Reading through this, I mean, I think there's some compelling arguments that your client thought the valuation was above 406. I mean, I've read all that testimony, and he looked at some metrics that may have been different, some of his own valuations, his sense from the marketplace. I think there's a fair argument that was his state of mind, but we're dealing with a clear error standard of review. And even if I thought you had the better end of the argument, how is the evidence that Judge Diaz talked about, the pre-existing $200 per share range valuations, not some evidence on which we have to conclude the district court was not clearly in error?
Because the district court's relying upon a single data point to make that conclusion, along with a finding that what's supported in that is a price was justified. This is according to the district court's own opinion at Joint Appendix 2411-12. The price was justified largely by erroneous assumptions that the ESOP would gain complete control over the company after the transaction. But if you look at the calculation of damages that the district court did in its opinion, that's found at Joint Appendix 2432. So he's justifying that Mr. Vinosky knew that the price was too high, largely on this issue of a control, right? The issue of control. But if you look at the calculation of damages, there's 4 different buckets. The first 3, a 3-year look-back period, discount rate, long-term growth rate, all technical valuation issues, none of which the district court found that Mr. Vinosky had any knowledge about, nor was he involved in, because it was the process of the trustee working with the valuation professional. The only issue was control. You know what the district court found was accounted for, that calculation of damages, $600,000 in change, less than 5% of the total of overpayment that the court found. So now we're going to.
Could I follow up with you? I may have misunderstood. I thought the district court's primary evidence that Mr. Vinosky knew or should have known that 406 was above the fair market value were the previous valuations that ranged from 215 to 280. And the control issue, Mr. Vinosky claimed, well, this was now a controlling interest. And so maybe that justified a higher share. And the district court had some response to that. I'm not sure that was all that compelling in my mind, but nevertheless, that was kind of a secondary reason why, a response to Mr. Vinosky's reference to a controlling share. And kind of going back to the clear error, you said it was based on one data point. I mean, even if I give you that, why is that not a valid data point? I mean, that's what clear error means, isn't it?
Yeah, but when you have the government who's litigated the case and they're saying that the price should have been $100 less than the court came up with, that data point by itself does not justify that Mr. Vinosky knew or should have known that the price was too high, particularly when the district court, again, the quote is, the price was justified largely by erroneous assumptions that the ESOP would gain complete control over Century after the transaction. That's what the district court relied upon.
What difference in the corporation functioning? Mr. Napier's last assessment was, I think, 285. That was his assessment. Between the performance of the company that year and the year he assessed for 406, what changed in the company? Cash flow or market or anticipation? I was looking for that in the record, and I must say, I didn't see much change. It looked like the corporation was going as it had been going, and Mr. Vinosky was proud of the company. He was proud of his employees. He wanted to keep them compensated for benefits after he sold his stock, that type of thing. But I didn't see anything that showed that sharp upturn from 285 to 406 over the period of 1 year that justified Napier's change from the prior years. And in that regard, I'd just like you to take into account also that there were his appraisal at 406 had some very curious components that were pointed out to him that really weren't justified, at least a fact finder could conclude. And he didn't take account of those in going to the 406. Instead, he came out at a number which was for the Vinosky's interest around 21 million, which was exactly the number that Mr. Vinosky's attorney told the bank the transaction was.
Entering the transaction should have looked at those components that build up the process, the assumption that led to the valuation, all the inputs. The district court very carefully found that Mr. Vinosky did not participate in any aspects of that process. All he looked at was the output, which he testified to. What he would look to in looking at evaluation was the share price. What was the output?
Well, that's my point. That's really my point. I'm accepting you at your point. The question you were challenging, I think, the court's ruling that Mr. Vinosky would conclude that the 406 was too high. And you were challenging that, and you started reciting opinions by other experts. But I'm suggesting that focusing on what Mr. Vinosky saw and how he acted based on the knowledge he had, I was bringing in these other factual points and wondering how you respond to them. One of which, it looks like the corporate performance didn't show indicia to justify a jump for 285 to 406 by the very same evaluator. And then that is reinforced, the questioning on that is reinforced by the challenges that were made to his assessment and he refused to respond to. So these are things all that were in the knowledge and in the discussions involving Mr. Vinosky. And I'm wondering, the real question I'm wondering is how do we say the district court couldn't have made that finding?
Well, I think you can, Your Honor, because it's not Mr. Vinosky's responsibility. This is the fundamental principle of ERISA, that you can wear a fiduciary hat for one purpose, but not for all purposes. And
well, that goes to your co-fiduciary argument. And I think when we get to that, that's a pretty persuasive point, I think. But he was also held for participatory, participating in it. And that's, you're more vulnerable on that one, I think. But
again, I think that the issue is that did he have actual or constructive knowledge? And the data point that the court comes back to is the issue of control. And again, the whole point here under ERISA's regime is that you want to make the person running the plan is a fiduciary of the plan and a counterparty to the plan. Do you want to make that person a roaming ombudsman for purposes of a transaction? Because if you do that, then you're going to ensure that now the selling shareholder is incentivized to affirmatively meddle in the process of the trustee in that process. Affirmatively, and there's the Department of Labor has brought that kind of lawsuit in the Middle District of Tennessee a few years ago. They brought a lawsuit against selling shareholders of the plan, saying that you were intimately involved with the trustee's valuation process and you were lobbying as to the ultimate conclusion of value. You were pushing the value in a certain direction. And the selling shareholder got sued in that case. So you're damned if you do, damned if you don't under this standard. That's
Mr. Colombic, can I ask? Sorry, I suspect that the push from that fiduciary in that case, I haven't read it, was a push to increase the share price, not to reduce it. So that's point number one. But I want to go back to the issue of control and why. I mean, I do think that's an important part of this calculus. And you made some arguments about how that didn't seem to be an important part of the district court's opinion. But I'm not so sure about that. I mean, I think if in fact your client had effectively and actually given up control, there might have been some justification for a much higher share price than had historically been the case. But the facts on the ground made it very clear that he was not giving up control. and that effectively, if anyone wanted to cashier him or his wife from the daily operation and management or authority over this company, that they would have to fire themselves. And that just seems to me quite odd, and certainly ample evidence upon which a fact finder could find that he must have known that and must have necessarily, or should have, as a fiduciary, engaged in some assessment as to how that would have affected the actual value of the stock that he was purporting to sell to the ESOP.
Judge Niemeyer, may I answer Judge Diaz's question?
Of course, of course.
The way to answer that question is to distinguish this case from the Brundle case in the Fourth Circuit. There were selling shareholders who sold their shares of stock. They retained warrants as part of the transaction. So, and until those warrants were paid down, the selling shareholders, not the ESOP, got to vote the board. So they got to approve the board of directors of the company. Here, the ESOP, in acquiring the shares of control, they were now 100% owner of the business, and the ESOP was the legal owner and had the legal right to vote the board. But ESOPs and ERISA plans they actually have to operate through people, human beings. And the fact is that a year or two after the transaction, those human beings acting on behalf of the ESOP were Adam and his wife, Carol Vanosky, nobody else. And so they had to act in the best interest of the plan in approving and voting members to the board. And if they didn't, they could be sued under ERISA for not acting in the best interest of the plan. That's a distinction from Brundle, where it was clear the selling shareholders got to vote the board. They had no obligation to the ESOP whatsoever.
All right, thank you. Mr. Silverman, we'll hear from you.
May it please the court, Stephen Silverman for the secretary. I'd like to first address one of the latter points that Mr. Columbus raised regarding selling shareholder liability in an ESOP transaction. The thrust of Mr. Vanosky's argument is that it would be unfair to hold him as a selling shareholder liable for the overpayment in a transaction in which he was the counterparty, the ESOP. But Mr. Vanosky was not just a selling shareholder. He chose to be a named fiduciary of the ESOP. With that choice came fiduciary obligations to the ESOP, which, as relevant here, included those set forth in Section 405A3. There's no selling shareholder exception to ERISA's fiduciary obligation and Section 405A3 liability. Not in the statutory
Just a minute.
text.
Just a minute. It seems to me you're jumping into what I think is probably your weakest point. But if I understand the record correctly, Mr. Vanosky excluded himself from participating as a fiduciary on this transaction and hired the bank as an independent fiduciary to carry it out, which functionally, he still had the title, but functionally, he took himself out. And I've always understood from these cases that in that circumstance, he would not be a co-fiduciary or a fiduciary. The argument, the district court found he participated because he had knowledge, but it also found that he was a co-fiduciary, and he challenges that. And now you're suggesting that was correct. I'm interested in your views on that.
Well, first of all, the district court made a finding that there was no formal recusal by Mr. Vanosky. But in any event, and this court discussed it in the Dawson-Murdoch case, whether or not he recused himself in the transaction, he never resigned as a trustee. There are two different types.
But he didn't function in this transaction in a fiduciary. He did not hire the appraiser. He did not review the documents or conduct the review. He did not participate in the meetings and where that was all discussed. In other words, he relied on the bank, on the advice of counsel, I think, on a bank as an independent trustee. Now, functionally, you want him to be an actual fiduciary in this transaction who had a conflict of interest. And that's a hard case to make. The district court did find that, but I think that gets a little dicey when you're looking at it closely.
Judge Niemeyer, I would refer to this court decision in Dawson-Murdoch. In that decision, the court explains there are two types of fiduciaries. There are functional fiduciaries under Section 321A, and then there are named fiduciaries under 102 and 103. And this court explained that a named fiduciary is a fiduciary and that a plaintiff does not need to plead that a named fiduciary is also functioning as a fiduciary. That would be redundant because a named fiduciary is always a fiduciary. So what that means—
But Mr. Silverman, I don't think Murdoch obviously didn't deal with these particular facts, whereas Judge Niemeyer points out Mr. Vanosky and whether or not he actually formally recused. That maybe he didn't formally enter a recusal letter, but he effectively did that, didn't he, by appointing the bank to sit in his stead as a fiduciary for this particular transaction? I think because he recognized the very conflict that would otherwise ensue. I mean, he's essentially he would then have to negotiate against himself. So he did. I mean, it seems to make practical sense to say that at least in this context, he was not acting as a fiduciary, even if in fact he was a named fiduciary for all other purposes.
Well, again, Judge Diaz, I would disagree that with the premise they need to be acting as a fiduciary. If you look at Section 405A3, that language makes a fiduciary liable for the breach of if he knows of the breach of another fiduciary and fails to remedy that breach. In this
Let me ask you this. This is hypothetical. I don't want you to assume that this is the way I take this case. But what if the fiduciary had a conflict of interest and said, I am recusing myself in front of the board, and said, I'm actually going to leave town and take a vacation in Europe while you guys consummate this transaction. I don't want to be involved. And he does that. They consummate the transaction. And the other fiduciaries, co-fiduciaries, breach. Is he liable?
No, under the facts that you described.
Why isn't he liable under your argument? He's a named fiduciary.
Because Section 405A3, Your Honor, the language only, it's not vicarious liability, and the department is not arguing.
I'm not talking about, he is a fiduciary. He's a named fiduciary. He's one of the board members, but he recused himself and left the country and denied any knowledge and didn't get any knowledge. The question is, you're saying he's not liable in that circumstance, and I'm trying to figure out why.
Because one of the elements of a 405A3 claim is knowledge of the breach. And if the individual left the country, as I understand your hypothetical, and completely left the scene and completely avoided all contact and actually engaged in that level of recusal, then of course that individual would not have knowledge of the breach by the other fiduciary and would not be liable under Section 405A3. So the element of it's in the statutory text of Section 405A3 that the fiduciary must acquire knowledge of the breach. And this court, and this court in Dawson-Murdoch did say that it relies on a departmental interpretive bulletin from 1975.
Let me go back to my hypothetical.
Okay.
The hypothetical is he's in Europe and another fiduciary sends him a telegram and tells him what went on, which revealed enough knowledge for him to know there was a breach. But he stays in Europe because he said, I recused myself, and he does nothing. Is he liable?
Yes, Your Honor, under Section 405A3. The statute
even after he recused himself formally to the board from the transaction and said, I am not going to participate in this?
Well, Your Honor, Section 405A3, you can't get away from the language of the statute. And the statute says that a fiduciary is liable for the breach if he acquires knowledge of another breach and fails to take efforts to remedy that breach. So the fiduciary, having, again, been a fiduciary and acquired knowledge of the breach, is required under the statutory text to take action. The Secretary's interpretive bulletin from 1975 that this court has said that it consistently relies on makes clear, as Mr. Vanosky says in his brief, that yes, a fiduciary is not necessarily liable for all other aspects of a plan, but that it has exceptions, and the exceptions are in Section 405A, the co-fiduciary liability provision. But the way to resolve your concern, Judge Niemeyer, is that he can resign as a trustee. There's no,
he doesn't want to resign. He finds a conflict on one transaction. And so he says, I want to tell you, I have a potential conflict. I'm getting out of this. I'm not going to participate, and I'm not going to vote. I'm not going to read the documents. I'm going to Europe. And so he does that. Now, the one exception I have to try to test your argument is one of the fiduciaries sends him a telegram, unsolicited, and tells him information that shows the breach. And he does nothing because he says, I've taken myself out. Now, you're saying that it's knowledge without function. There's no functional aspect in that analysis?
Oh, Your Honor, and Dawson-Modoc makes that clear. The Section 405A does not contain a functional or activity aspect except for remedying the breach.
All right,
and
we'll take a look at that. All right.
Okay, and the functional yes, Your
Counsel, if I could ask just a kind of basic question of how a case like this gets started. This is being brought by the department. Some cases get brought by employees or participants in ESOP's plan. Is this, or is there, are any of the ESOP participants in any way supportive or not? I don't know that ends up mattering. I'm just curious as to whether this is brought completely by the government or whether the ESOP participants have any, support for it at all.
I'm not aware of any support one way or another. We do have protections that we have in place for when there are complainants, along the lines of informer privileges and things like that. But at this time, I'm not aware of, there's nothing I can tell the court one way or another.
Okay, well, I don't want to put you in a bad spot. I'm not trying to get, information that's not allowed to be disclosed. It's just, some of my questions, talk about the standard review here, but it's kind of an ironic case because there's no indication of any discomfort from the employees. They seem to be treated remarkably well. It's just an ironic sort of circumstances how this has come about. Maybe it's okay legally, but I just wanted to understand that.
Okay, and what I can say is that oftentimes employees are not in a position to know sufficient information that they would raise a concern. For example, they would not necessarily have access to the valuation report. They would not have access to the processes and procedures of the fiduciary. So a participant in a plan would only have limited information. And that's not to say that there isn't private litigation regarding ESOPs, but in any event, that doesn't affect the department's own investigation.
Mr. Silverman, can I follow up on this? And I don't want to beat a dead horse here, but it's interesting to me. I want to know why the department is so hung up on affirming all aspects of the district court's decision here, in particular the co-fiduciary portion of the decision, which I think is problematic for the reasons that you might already have surmised by virtue of the questions we've asked, because there's an alternative theory here, right, that more than amply encompasses the very liability that the district court found, and that is that notwithstanding whether or not he was a co-fiduciary for purposes of the transaction, that he still has, there's still the issue of knowledge and the question of liability and that aspect of ERISA. So why is it a concern that you want to hang on so strongly to this co-fiduciary prong of liability in this particular context?
Well, if I understand your question, Judge Diaz, the fiduciary provisions of ERISA are the preeminent provisions of ERISA and that protect the employees and the participant. So if I understand you're referring to the not knowing participation claim under Harris Trust, there are, an individual who is liable as a non-fiduciary knowing participant, which is an alternative finding by the district court, is obviously another critical component of ERISA. But the department, in looking at protecting participants, certainly primarily will focus on a fiduciary claim because the fiduciary has an obligation to the participant to act in the best interest of the participant, whereas someone who is not a fiduciary, for example, if Mr. Vanosky had not chosen to be a fiduciary for purposes of a transaction in this case, then that would be a different type of a case where he doesn't have 405 liability, for example. So I think it's just a bit of belt and suspenders on the government's part But the most preeminent theory of imposing liability and protecting participants is to proceed through the fiduciary, holding individuals liable as fiduciary.
Okay, so let me let's move on because I want to get to the sort of the principal theory of liability here. And you heard your colleague on the other side saying that there's no way that Mr. Vanosky could have or should have known about the reasonableness of this transaction because of the widely varying estimates of value that attach to this stock from different experts, across the board, some too high, some too low, and the like. So I'd like you to respond to that.
Well, for starters, I think Judge Quattlebaum and Judge Niemeyer had it correct with the finding that Mr. Vanosky knew the price was too high is subject to clear error review. And that finding that he knew that the price was too high is supported by the evidence. So Mr. Vanosky, he's not just a layperson on the street. He's the founder, the CEO, the president, the chairman of the board of Century. He ran this company. It's not surprising, therefore, that after he sold half of his stock in 2004 for $9 million, he reviewed the annual appraisal that topped out at $285 per share in 2009. And then in 2010, when he wanted to sell the rest of his stock, the share value jumped by 40% to $406 per share, even as the company struggled. And anybody would know, and I think Mr. Vanosky in particular did know, given his knowledge of the company, that price was way too high. He controlled the company, he ran the company, and he was the company. I think, as Judge Niemeyer referenced, there was no business reason to justify such a sharp increase in the price. That increase would be significant for any company. And what is problematic here is that, as Mr. Vanosky indicated in his reply brief, Century ended up outperforming expectations in 2010. But as Napier testified, expectations in 2010 were so low that even when the company exceeded expectations, it underperformed the poor-performing years of 2008 and 2009, all of which Mr. Vanosky knew. If anything, the stock should have been worth less in 2010 than in 2009. And the decision below...
Well, but let me jump in a little bit. I mean, you don't have to convince us, I don't think. I mean, your arguments, I understand those arguments, and they prevailed. And, to me, there's, significant evidence the other way. The point is what we do in our role, and all we have to show is, or the only thing that is our standard is clear error. And so, I mean, just from my perspective, it seems like we don't need to go with your theory hook, line, and sinker. We just need to, have evidence that, there's some evidence that supports the verdict or the decision. And that, anyway, I just caution you. I mean, there's compelling evidence both ways here. I got one question I'd like to deal with on a separate topic. The district court said that the Brundle decision bound him to deny the offset of the debt reduction that came after this transaction. I've read Brundle carefully several times, and it seems like a very different case than this. Is it your position that Brundle compels that result?
Yes, Your Honor. While the Brundle, of course, dealt with a subsequent stock sale rather than debt forgiveness, but the principle remains the same. And the principle is derived from the Henry decision out of the Second Circuit, which says that if the ESOP somehow comes into money in the future that is unrelated to curing the overpayment or remedying the overpayment, then that unrelated money or fund cannot be used to offset the overpayment. So while the Henry case and other cases have rejected every court has rejected the offset of a unrelated debt forgiveness, the Brundle case simply took that principle that unrelated money that the ESOP may receive cannot be used to remedy and applied it to the subsequent stock sale that occurred. The principle remains the same. that it
Well,
was
maybe it does, but or I don't know that it does. Let me just say, I mean, Brundle, as you note, involved an appreciation from a third-party purchase, and the debt reduction that and that was the vast majority of the opinion on the offset. There was discussion of the debt reduction that occurred as part of that transaction, but it seemed to me the reason this court found that was unrelated is that debt reduction was solely to make that third-party transaction go through, and here we're dealing with the original participants, and if you're right, the amount of damages is the delta between the fair market value and 406. Plus, in effect, an additional 4-point-something million. I don't see how you can really credibly say you've lost $6 million when 4.6 or whatever has been forgiven.
Well, what I would say, Your Honor, first of all, is that just as the debt forgiveness in Brundle was for the purpose of getting that third-party transaction put through, the debt forgiveness in this case was for the purpose of helping out, essentially during a downturn in the bottling industry, not to help the ESOP. And as we explained in our brief, that's common sense. If we gave the hypothetical that if someone sold a fake painting to somebody for $10,000 and then 4 years later attended the buyer's wedding and gave them $500, they couldn't later in a civil fraud suit claim that they can offset the $500 for the wedding present from the wedding present against a civil fraud. So the idea of unrelated.
I agree with you on that, but I mean that seems like it's changing the facts. I mean, they reduced the debt that was owed for the purchase price. If someone, and to use your hypothetical, if the seller or the purchaser of the painting sued them for overcharging them for the painting, but in between that time there had been a reduction in the purchase price, they wouldn't get the original purchase price. They'd have to look at what the reduction was.
What I would say, if I can just respond to that, Your Honor, over my time, is that there are ESOP transactions that occur where the transaction documents include in them a future potential offset if the company happens to miss earnings. But they contemplate at the time of the transaction that a debt reduction will occur in the future if the company, again, misses earnings and so underperforms expectation. And in that case, the department would agree, because that's for the purpose of curing the overpayment, that a debt reduction, debt forgiveness would be appropriate as an offset. But those are not the facts here. The facts that Mr. Vinosky, forgave the debt to spare the company a downturn in the bottling industry has nothing to do with curing the overpayment.
Mr. Sullivan, can I follow up on? I'm sorry. Can I follow up on Judge Quattlebaum's question about this issue? So, there's Brewster, and then there's this other case called Henry, where the court purported to offer a rationale for why an offset would not be appropriate. And as I understand it, the concern is that because the company is taking on debt, it's incurring additional consequences, economic consequences and damage as a result of that debt, even before the borrower begins to repay it. That seems like a damage argument. I mean, if that's the theory, I know you have a theory about whether or not it's related or not, but if the theory is you want to make the ESOP whole, why shouldn't that be a part of the damage calculation on the front end? And why should that at all affect the ability of Mr. Vinosky in this case to obtain an offset for a reduction in the very debt that he assumed that based on the original stock transaction?
Well, if I'm understanding your question, Judge Diaz, I think it goes to what was the purpose of the debt forgiveness. And under Henry, if Mr. Vinosky had said, I'm going to forgive $4.6 million in debt in order to cure the overpayment that occurred in 2010, then we agree that would be a proper offset. That is not what occurred here. He forgave the debt to spare the company a downturn in the industry, and that does not cure, as you mentioned, the overpayment that occurs the day of the transaction. it's unrelated and therefore isn't a basis for an offset.
Let me
Under
ask
Henry
you-
and Brewster,
The damages were calculated not on that first transaction, was it? It didn't come into play. It was the second transaction on which the damages were calculated. Is that right?
correct, the 2010 transaction. I don't know if I misspoke.
Yeah, and that involved what, half the stock of the company, or roughly half?
Yes,
And so the forgiveness related to the first transaction when he sold of the first portion of the stock. Is that right? The ESOP incurred an indebtedness with respect to the purchase of the first hunk of stock, right?
by the time the 2010 transaction occurred, the ESOP had essentially paid off in the entirety of the
I
first.
understand, but I'm just
Okay.
trying, and these are maybe a little bit softballs, because I understood that the forgiveness of the debt did not relate to to this transaction in any way. It related to an earlier transaction, which had pre-existed and was unrelated to the final buyout. Am I assuming that correctly?
Are we talking about the forgiveness by Mr.
Yes,
Benoski?
he forgave a debt. What was the debt incurred for?
The debt that was incurred was related to a second transaction. According to the district court, the first transaction, the debt had been paid off by the time of the transaction. So regardless so does that answer your question?
So you're arguing basically this is like a collateral source rule. In other words, that the payoff was not related to overpayment, but was related to an industry condition.
That's correct, Your Honor.
All right. I'd like to ask you one unrelated question before you sit down. I know we've got you over time here. There was this email in the record where Mr. Gust, the attorney for the company, was soliciting the bank to become a trustee and referred to the transaction as a $21 million transaction. It turned out later that Napier came in with his appraisal at 21 million. My question is, where did Gust get that number? Does the record show?
According to the email itself, it says that Napier has advised that the transaction will go forward at 21 million.
Before the Gust said that before Napier did his appraisal?
Correct. That's the
Does the
finding by the
record
district
show where
court.
Napier got that number?
No, Your Honor.
All right,
I
thank you.
believe.
Oh, go ahead.
I believe Mr. Napier denied providing that number, but I'm not sure about that, Your Honor.
The reason I'm asking is the question, you try to put together the puzzle in this and you try to find out the degree to which Mr. Benoski knew what was going on or participated, and there could be an implication or an inference that he had discussed selling out his share with his attorney and with Napier and said, how we go about this. And the attorney says, you need to get an independent trustee to avoid a conflict. And so then the attorney sends a letter to the bank saying this is a $21 million transaction, which suggests that before Gust wrote that email, he had had some kind of discussions, in-house discussions as to, explaining how this goes forward, and it'd be which might be imputable to Mr. Benoski. But you're saying that source of that number is not clear.
Well, no, what I'm saying is that email, and I can read it, it quotes, Mr. Gust stated, quote, the value of the remaining stock as determined by Brian Napier is approximately $21 million. That's what the email said. So,
and Napier he'd not done any appraisal at that point, had he?
No, and that, Your Honor, that goes to some of the deference that we afford to the trial court, because I know that Mr. Vanosky would say that there's only a single data point to justify the district court's finding, but there's a lot going on here, including that email traffic, including the rush to complete the transaction for tax purposes, the lack of any negotiation with Mr. Vanosky. There's a lot going on that the trial court heard the witness testimony and was able to render that decision that he knew the price was too high. For the reasons
but Mr. Let me just make sure that, I mean, there's a lot going on, and those all relate to Evolve, and the district court, the things you're talking about now, the district court specifically said he not only didn't know, but he should not have known about. So this really comes down to the knowledge of the 215 to 285 shares before, and whether the 40% increase would have been enough. I mean, that's based on the district court's finding, really it. Now, that may be enough under a clear error standard review, but all that other stuff that's going on, tied to Evolve, and the district court found that Vanosky didn't know about it.
Respectfully, Judge Quattlebaum, Mr. Vanosky would have known that there was no negotiation on the part of of Evolve, because he would be the counterparty to that negotiation that didn't occur. There is a finding by the district court that Mr. Vanosky was aware that the transaction was being pushed through for tax purposes, in order to benefit for tax reasons, and I'll leave it at that. And with respect to the email traffic, you're correct. There's no finding that Mr. Vanosky was on the email traffic. But as Judge Niemeyer indicated, when Century's lawyer sends an email, when Michael Coffey sends an email, who's someone hired by Mr. Vanosky to work on the ESOP deal, when people are sending these emails that are basically signaling the $21 million price before the appraiser has done anything, and inferences might be drawn by the district court about what was really going on here.
I guess Judge Quattlebaum's point, though, is the district didn't rely on those. He didn't reach inferences from that. Is that correct?
I think that's correct, yeah.
Okay, thank you. All right, why don't we hear from Mr. Kolumbic again? You have some rebuttal.
Thank you, Your Honors. To the point of the knowing participation claim, the legal standard, and I understand it is a clear error standard, but the standard was the knowledge, was it obvious to the person? And again, the point for providing those different...
So I hate to interrupt you right off the bat, but that's an important point, and it's the first we've talked about it. I mean, I spent some time on that, and it looked like the obvious standard that, I realize that your argument, how you got there, but the cases that talk about that are Eighth Amendment cruel and unusual punishment cases. I don't see how there's really support that this has to be obvious. Now, there was the debate about whether you just need to know the facts or know whether there's a breach, and I'm convinced you need to know whether there's a breach, but the obvious standard, that just seems like a remarkable stretch when all the law that really talks about that is Eighth Amendment cruel and unusual punishment.
Yeah, if you go to the Intel decision, which is the most recent ERISA decision, to quote the Farmer case, they quote it and they say that the Farmer stands for the proposition that they use the quote usual ways to infer actual knowledge, and those usual ways they cite to the Farmer case specifically, because I understand that it's a progeny of Eighth Circuit cases, but I believe that the Intel decision affirms that the legal test is obviousness. And if you look at those four different valuation data points, they're all over the spectrum. And respectfully,
why do you say that? They consistently, it started at 215 and went up from year to year to 285. That was perfectly, and he also had a transaction at that level. That to me, those 3 or 4 data points are all pretty consistent with each other, aren't they?
Respectfully, Your Honor, I'm talking about the valuation experts, all the Department of Labor's expert who came in at $180 a share.
But when we're looking at evidence, we got to look at evidence that was seen and known by Mr. Vanosky.
And on to that point, you had a company that was growing consistently before the Great Recession. It hit the brakes like every other company did. But when you're valuing a company, as you were doing in 2010, at the end of 2010, going into 2011, you're looking at what are the forward-looking prospects for the company? And this company looked like it was company on the rise, heading out of the Great Recession. So again, we respectfully submit there may be evidence on both sides, but that does not pass the obvious test. With respect to the offset, again, Brundle looked at both Henry decisions. In the first Henry appeal decision, they looked at the question what the Second Circuit sent back to the district court in that case, which is in that case, like this one, where you had selling shareholders voluntarily agreeing to give up ESOP debt, does that impact the district court's calculation of damages? And the Second Circuit said you should look at that to make sure that we avoid a windfall to the plan. And a great way of looking at this is let's just assume instead of Mr. Vinosky forgiving a partial part of the ESOP debt, which goes back to the $21 million transaction, he forgives all the debt. In that case, you now have an ESOP that owns 100% of the shares of stock. It didn't spend any money because there was no loan repayment obligation to do it. And it's getting $6.5 million in damages as part of an award. That's a windfall. That principle is no different here when you have a partial loan forgiveness, which is what happened with Mr. Vinosky. Unless the court has any further questions, I don't think I have anything else to address on rebuttal.
All right. Thank you, Mr. Columbik. We appreciate the argument of both counsel, and as you both may know, our custom and practice is to come into the well of a court and shake your hands. And this Zoom business has not allowed us to do that yet, as far as I know. But I do want to extend our greetings as if we were in the well of the court shaking hands. And thank you for your argument.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
And we'll proceed to the next case. Three of you on? Okay,
Yes.
I see. Okay, thank you. We'll hear it first from Mr. Sukup.
May it please the court, Jeffrey R. Sukup for the petitioner, Consolidation Coal Company. The ALJ in this Blackland benefits case thrice considered conflicting medical evidence. Twice he denied benefits as the evidence rebutted a presumption of disability due to pneumoconiosis, which applies in this case. The Benefits Review Board, however, vacated both of those benefits denials and effectively ordered the ALJ to consider the agency's opinions about pulmonary science, which are expressed in the preamble to the Blackland Benefits Regulations Amendments in assessing the medical expertise. And on the third time, after the ALJ complied with that order, he completely reversed his prior findings, awarding benefits, claiming he now found some experts to be contrary to the preamble, others to be consistent with it.
Your voice is dropping a little bit. Is there something, are you near a speaker? Maybe you just stay a little closer to this, wherever the sound's going in.
I'll try my best. Is that better?
Yeah, that's pretty good.
My apologies.
No problem.
The board exceeded its authority by ordering the ALJ to measure medical experts against the tenets of the preamble. While an ALJ may consult the preamble in assessing medical evidence, he cannot be required to do so. And the reason why is because regulations or rules, which are issued through notice and comment pursuant to the Administrative Procedure Act, do have the force of law. The preamble, however, which essentially just contains explanations about the changes in regulations and other information from medical science that the department considered in amending the regulations, was not issued through notice and comment and cannot be given the force of law. By requiring the ALJ to measure doctors' opinions in this case against the preamble and the Department of Labor's views of science expressed in the preamble.
Well, on that question, let me just ask you, and it may be of no moment, but I thought there was a distinction, effort made to make a distinction between a direction to consider the preamble and take it into account and to consider a claimant's argument made under the preamble, which the immigration judge, IJ, could just really reject. Is that meaningful? But because the board remanded it to consider the claimant's argument based on the preamble. Isn't that right?
That's the distinction that the board and the director have made in this case.
Yeah, okay, just address that. Yeah.
Sure. My position would be that that is a distinction without a difference, because whenever you are remanding, in this case, if you're remanding for the ALJ to consider the argument about whether the consolidation's experts' opinions conflict with the preamble, you necessarily have to consider the preamble's positions, compare them to the medical experts' positions, and determine whether there is conflict. My position is that the case law confirms that the ALJ is under no obligation to consider the preamble in the first place. He can, because he can look at that and consider it as comparative. But in this
Mr.
case,
Sukup, Judge Diaz here, I'm sorry, but I guess the question is whether in the previous ALJ opinions, the ALJ made it clear that he wasn't going to consider the preamble because he wasn't required to, or whether he simply said nothing about it, in which case the board properly put him to the analysis. Consider this argument, decide whether or not the argument is consistent or contradicts the preamble, and if so, whether or not that makes the expert opinions less or more credible. And I think embedded in that is a discretion for the ALJ to not consider the preamble because it's not required. But I mean, if the ALJ didn't engage with that analysis, why wasn't it appropriate for the board to require it to do that?
Well, Your Honor, even if you accept that premise, even the director concedes in her brief that not all arguments have been properly raised have to be considered at all by the ALJ. That appears to be the position of the director, that basically some arguments are more important than others. Some arguments must be considered. The preamble is one of these, and that's not at all borne out by this law in question.
Well, to counsel, I think this is an important point. And I may not have this completely right, but it seems to me it's decided really about how we consider, really three concepts. One is, the scope of review that the board has in these black lung cases. And the regs seem to restrict that scope of review more than general agency law, and seem to limit it only to whether there's substantial evidence or not. On the flip side, you got the 557, which says you must consider all material facts and legal issues. So I guess the issue might be whether the preamble, the argument that is made by Shipley concerning the preamble, is a material issue or not. Is it your position that it's not material?
The 557 standard you referred to is that the fact finder or the tribunal has to consider all material facts overall. The preamble is neither. It's a position advanced by one party, in this case, the director. It can be considered. The ALJ has discretion to consider it, certainly. But like all other arguments, an ALJ does not need to necessarily consider it in deciding benefits. Apparently, in this case, in the first two decisions, the ALJ felt it was of no concern because he believed that my client's experts were credible, notwithstanding any alternative theories of medicine advanced by the court. In any event, I know I've spent a lot of time on this issue, but this is kind of interesting in that the preamble arguments are largely immaterial because in this instance, the biggest preamble argument advanced by the other parties are that Drs. Block and Bashida, my client's experts, advanced a theory of what's called the FEV1 ratio. This is generally speaking, the FEV1 ratio is a standard by which you judge whether somebody has obstructive lung disease. The theory advanced by the Department of Labor is that Drs. Bashida and Blanc relied on a claim that the FEV1 ratio does not deduct at all, does not diminish in response to coal mine dust exposure. And the ALJ adopted this theory and found that my doctors are contrary to the preamble because of that. The problem with that is that neither doctor ever expressed such a view. Dr. Bashida, who submitted a written report but not a deposition, expressed no view at all on the relation of the ratio in response to coal dust exposure. Dr. Blanc provided both a report and a deposition, and despite numerous times in the deposition from the claimant's counsel trying to get Dr. Blanc to adopt this forbidden view, if you will, he rebuffed it every time. Dr. Blatt said, no, I don't agree with you with the proposition that coal dust does not significantly reduce the ratio. I mean, in my opinion, just reading this deposition and these reports, it couldn't be clearer that these doctors did not express this view that was contrary to the preamble.
So
yes.
help me understand. I mean, I appreciate that point, and to me, I'm trying to think where it fits into the analysis. It seems like our first decision point is the second board decision. Because does the board have the authority to require the ALJ to consider an issue if it otherwise is supported by substantial evidence? And I think, because I don't think, by requiring the board to consider the issue, it prohibits the ALJ from saying what you just said. And the board didn't say, that in the second opinion that there was any opinions contrary to the preamble. It just said consider them. So I think it seems like the first issue was that second board decision right? And if it wasn't, that may end the case. If it was, then we go to the third ALJ decision and see, and measure it. And I think that argument comes into play in that third ALJ decision, but does it come in before then?
Well, the issue of whether the board properly remanded to consider the issue or the argument comes in at the second board decision. I agree.
Correct.
I think, as I said before, I think under 5 U.S.C. 557, the board, as considering that it's a statute, the board would have authority to require an ALJ to consider material facts or law. But again, and even the director concedes this, I don't think the board has authority, or I don't think there's any requirement that a fact finder is required to consider every argument that's advanced. And I would submit that's even
that's a clear proposition, but that doesn't answer it. In other words, if the board chose to have the IJ to consider it, doesn't it have authority to tell them so?
I don't think the board is required to require.
Not required. It exercises discretion to tell the IJ to consider this argument.
No, not if there are no other factual errors in the ALJ's decision. And in both of the benefits denials, the ALJ reviewed all the experts, found that my company's experts provided well-reasoned opinions, and I think that should end at the review because that decision was supported by substantial evidence and was not irrational.
So on that issue, I mean, if that's true, that's different than the way agency law generally works, it seems to me. Generally, an agency has all the powers that the decision maker below, the ALJ or whatever, has, and it's common to say consider an argument. Is there something? Is your position that I'm wrong about that, or is there something unique about this black lung context where the board's decision, the board's authority is more limited?
I don't think there's anything in the statute or in the regulations by which the board can simply send a decision back because it feels that an ALJ did not consider one argument or another. I think if the ALJ's decision on its own terms is rational, is supported by substantial evidence, and is not contrary to law, then that should be the end of the game for the board in its consideration. And I submit to you that was clear in both of the ALJ's two decisions in which he denied benefits. He considered all the evidence advanced by the parties. He identified defects in the claimant's, Mr. Shipley's experts that did not warrant giving them any substantial weight. He found that my company's experts were supported by substantial evidence and were rational, and by token of that, denied benefits. However, Judge, I can't really stress this enough. Even if you accept the way that the director and the board have positioned this, and that it's just allowing them to review an argument and they're properly allowed to do that, they meaning the board. Again, there was really no conflict with the preamble for the ALJ to have found in the first place. The alleged conflict is that Drs. Blatt and Bashida said that the FEV1 ratio does not reduce with coal dust exposure. Again, that's not present in any of their opinions, any of their depositions, so there was no basis on which to even find a conflict in the first place. Judge Quattlebaum, that takes us to the third ALJ decision, as you hinted at before. And if that's, can I just finish my response, Your Honor?
Yes. Yes.
If we get to that point, yes, we do need to review the third ALJ decision for consistency with the law, and that's where the errors are found at that point. finding a conflict with the preamble not borne out by any evidence, let alone substantial evidence. And that would result in at least a vacator, if not a reversal.
All right, thank you. Ms.
You're
Hurley,
welcome.
we'll hear from you next.
Morning, Your Honors. My name is Sarah Hurley, and I represent the Department of Labor, Office of Workers' Compensation Programs. The main issue before this court is whether in 2016, the Benefits Review by remanding a case for consideration of claimant's argument that employers' experts' opinion were flawed by reliance on a theory that was at odds with the medical science as set forth in the preamble. In employers' view, BRB's instruction impermissibly imbued the preamble with force of binding law, but employers mistaken. The board's order did not imbue the preamble with a force of law.
I understood that to be his argument after reading the briefs, but on questioning today, it's a little bit different as I understand it. I think what he is saying that the second ALJ's opinion was not erroneous on its face, and the board sent it back to consider an argument that was not justified in view of the fact that there was no error in the ALJ's second opinion. In other words, the board doesn't have a right to look at an argument that wasn't considered if the ALJ came out with an opinion that satisfies all the criteria of a proper opinion. And so if I understand him, he's saying that while the board has a lot of discretion to send things back, it can't in the face of a proper opinion. It has to either, it has to find some reason to open the opinion up and remand it.
Well, with respect to the ALJ's second opinion, there were flaws that the board identified in addition to the fact that the ALJ did not address claimant's argument about the FEV1 ratio.
Well, counsel, if you could, to just finish Judge Niemeyer's point out, if assume, and I'm not suggesting you're giving this up, but assume the opinion is otherwise acceptable, supported by substantial evidence, not contrary to law and adequately explained. The company's point is if that's the case, it's improper for the board. The board doesn't have the ability to say, consider this other argument, because one, they don't have to consider every argument. That's the general rule. And two, this particular argument has been held by us already to be something that does not have to be considered. So what authority, if you take my hypothetical, which I know you disagree with, what's the authority of the board to send back to consider an argument if the opinion is otherwise satisfactory?
Well, the problem is the Administrative Procedure Act. I mean, that instructs the ALJ to make findings and conclusions on all material issues of fact or law discretion presented on the record. And here the claimant's argument on this issue was clearly material because it was potentially dispositive. And that's because this court even has recognized that the medical opinions based on an invalid the FB1-FBC ratio are contrary to science expressed in the preamble and can be discredited on that basis.
But I grant you that's the argument, but your colleague says it's not a fact and it's not a law. So, it doesn't say all material arguments. It says, all material facts and law. So where do you fit? How do you fall within that portion of the APA?
The APA instructs the ALJ to make all findings and fact and conclusions on all material issues of law, facts, or discretion presented in the record. And in this case, the claimant's argument is material. It's a material issue of law. Because
okay, I appreciate your argument. Thank you.
Ms. Hurley, can I ask a follow-up? So I don't know that you fully answered Judge Niemeyer's earlier question, and I appreciate Judge Quattlebaum's hypothetical, but in addition to this concern about whether or not the the ALJ erred in not considering arguments based on the preamble, there was also this problem of burden shifting with respect to clinical and legal pneumoconiosis. And in both cases, the board said that the ALJ improperly shifted the burden to the petitioner as opposed to the respondent with respect to contributing factors with respect to black lung disease. So, I mean, that was part of the reason, frankly, I thought a substantial part of the reason why the board was sending the case back, in addition to this concern about not addressing the argument regarding the preamble. Do I have that? Do I have that right?
Definitely with regard to the ALJ's, to the board's first order remanding this case in, I think it was 2015. They did identify that clear error in the ALJ's analysis, and actually, employer doesn't dispute that the ALJ did shift the burden of proof in his first decision.
But I thought the board mentioned that also in the second opinion.
I think it was only in the first. It was in the context of the 15-year presumption that he did shift the burden of proof. The other point that was in the second board decision sending it back, there were other grounds too, and one of them was that the employer's experts hadn't proved that this miner's 40 years of coal mine employment wasn't an additive risk to the development of his totally disabling respiratory impairment.
I'm quoting the board decision here, and I hope I have it right. There's a footnote in the board's second decision that says that the ALJ quote, made no findings regarding the existence of legal and clinical pneumoconiosis under the standard, and the rest of it is not a quote, but under the 15-year presumption. So, I mean, isn't that something else in addition to this issue about the preamble that had the board concerned?
Yes, there was. Yeah, definitely. They identified other errors in the decision, not just the failure to consider claimant's argument. And with regard to the fact that I think employer is arguing that its experts didn't espouse the FEV1 FVC ratio. With respect, they did. It's Dr. Beloy clearly said that a reduced FEV1 FVC ratio indicates tobacco-induced lung disease. And Dr. Bachita said that that type of reduced FEV1 FVC ratio is indicative of asthma. So it seems to me they were definitely denying the fact that a reduced FEV1 FVC ratio was not indicative of coal mine employment, which is contrary to the preamble and the regulations. Your honors have no further questions, I think.
All right, thank you, Ms. Curley. Gribler?
Thank you.
Thank you, Your Honor. May it please the court, my name is Matt Gribler and I represent Mr. Shipley, a respondent in this case who is a coal miner with more than 40 years of qualifying coal mine employment and a totally disabling respiratory impairment. That entitles him to the invocation of the 15-year presumption, which shifts the burden to the employer to prove the absence of legal pneumoconiosis. We can agree that he disproved clinical pneumoconiosis, but the employer then has the burden to disprove legal pneumoconiosis. It's defined as a lung disease significantly contributed or substantially aggravated by coal mine dust exposure. Now, the board held, and I can read from the board's decision, it's at the joint appendix, page 432, in light of the medical science found credible in the preamble, finding the effects of smoking and coal dust exposure additive, the ALJ permissibly found that neither physician adequately explained why claimants' more than 40 years of coal mine dust exposure did not significantly contribute along with the other factors. Now, I tend to disagree just a bit with the director here in that the director would limit the board's decision affirming the administrative law judge's credibility determinations to just one factor, that being the additive effects of smoking and coal dust in the preamble. My reading of the board's decision is that they affirmed the judge's finding that in light of the preamble, acknowledging additive effects of coal dust and tobacco smoking, they affirmed the judge's decision that Doctors Balat and Bashida didn't adequately explain why claimants coal dust was not a factor. And the judge gave multiple different reasons to discredit Doctors Balat and Bashida, which have all been before the ALJs, the board, and this court many times and have been discredited by the ALJs and affirmed by this court. The first of which would be reliant.
Counsel, can
Yes.
On this point, can I stop you? And many times with agency decisions, we review the final, board decision, and that's what we're limited to. And in a situation like this, where the board appears to rely on one of the ALJ's reasons rather than others, normally we look just to that reason, and we'd have Chenery issues if we, didn't do that. It looks like our law says that in this context, this particular agency context, we actually review the ALJ decision, yet we step into the shoes of the board. Do you agree with that?
Judge, I do agree with that, and I believe we still reach the same decision here.
Yeah, I understand your argument. I just wanted to make sure, and if the company's counsel could maybe address that. I just want to make sure I'm understanding how we review this thing going forward. And I have one other question related. If we are at a position that we look at the third ALJ opinion, can we look at its, whether it is a proper opinion, whether it's arbitrary, all the things that are complained about? Are we confined to the four corners of that opinion, or can we look at it in relation to its earlier opinions that it issued?
Judge, I think you can look at the third opinion in addition to the portions of the first two opinions that weren't vacated by the board, because if my recollection is correct, I don't believe the board.
The light was green and then said the light was red. I mean, that can't be part of our analysis at all. Is there any authority for that?
Well, Judge, I think first of all, the opinions of Dr. Schaff and Bagley, which the judge made an about face on, the judge's treatment of those in the third decision are harmless error. They're irrelevant because it's the employer's burden, and the employer has to produce credible doctor's opinions to meet its burden, no matter what credibility is given to Dr. Schaff and Bagley. So in looking at Dr. Schaff and Bagley's opinions, the board vacated the judge's decision with regard to Doctors Balat and Bashida, based in large part on this FEV1 argument, which the judge failed to address in his first two opinions. And in fact, in the judge's second decision and order, he actually credits Dr. Balat based on that FEV1 ratio theory. At Joint Exhibit 387, the administrative law judge says that Dr. Balat opined that claimant's FEV1 FEC ratio showed cigarette smoking caused claimant's pulmonary impairment, not coal dust exposure. And then in the next paragraph says the undersigned finds these explanations well-reasoned and well-documented. So not only did the ALJ fail to consider claimant's argument that the FEV1 ratio was contrary to the preamble and hostile, but he in fact credited that FEV1 ratio theory espoused by Dr. Balat. And I think, to answer your question, the board vacating that part of the ALJ's decision, I think it tends to direct this court to review only the ALJ's third decision with regard to the credibility determinations from Dr. Bashida and Balat, because the board vacated the judge's first two decisions because he failed to even consider the preamble and the case law, which allows a judge to consider that preamble in making credibility determinations. Now, I mean, just to touch on the argument made by director, the board didn't force the judge to discredit the doctors based on the preamble. Instead, what the board said was, Judge, just address it. Tell us, recognize, does it conflict or not? And if it does, are you still going to credit the doctor's opinions despite that? Or are you going to discredit the doctors as a result? And judges, I see my time is up, and thank you.
All right.
Mr. Gribler, I'm sorry, Judge Niemeyer, can I ask a question? And Mr. Gribler, this is a broader question that has some relevance to this case, but and as a function, frankly, of the fact that, at least for me, I don't see these cases all that often, and so don't claim to be an expert when it comes to black lung cases. But so you've got this part of what Judge Quattlebaum said about the red light, green light kind of resonated with me, because it seemed you could sort of read between the tea leaves that the board wanted to prod the ALJ to revisit this case very carefully. But in your experience, I mean, the rebuttable presumption is intended to be rebuttable, but I've not yet seen a case that I've been on the panel where an employer has been able to rebut that presumption. Have you lost any of those cases when you've got the rebuttable presumption in your favor? And I don't want you to tell me what your track record is, but I'm just curious about that.
We have, Your Honor. We haven't appealed any of those to this court, but we have lost cases where we have the presumption. And that happens where maybe there's objective testing, whose numbers meet the Department of Labor qualifying guidelines in addition to 15 years. But then a doctor, for example, our physician, or the Department of Labor physician, renders just a conclusory opinion that coal mine dust caused the disease here, and employers' doctors present a more well-reasoned and more well-documented opinion. And that happens more often than you think, Judge.
Okay. Well, that's helpful. I appreciate it. Thank you.
All right. I guess we're back to Mr. Sukup, and you have some 3 minutes rebuttal time, I think.
We can't hear you.
You'll have to turn your mute off.
My apologies.
Good.
First of all, there appears to be a great deal of misconception about what argument about the FEV1 ratio is actually contrary to the preamble. The Director's Council is giving the impression that any discussion of the ratio at all, no matter regardless of what they say about the ratio, makes it contrary to the preamble. At least that's how I take their argument. That is not so. The argument.
Well, I think what he's saying, what is being said is that if there is a determination of the ratio that's inconsistent with the science expressed in the preamble, then there ought to be an explanation as to what science is governing and why.
I know, but
I think that's the point being made, isn't it?
With all due respect, Your Honor, I would not put it that way. What the director seems to be saying is that Drs. Bashida and Blat are contrary to the preamble because they are discussing the FEV1 ratio in their opinions. What is contrary to the preamble is the opinion that the FEV1 ratio does not significantly decrease in response to coal mine dust exposure. Neither doctor took that position. Dr. Bashida does not discuss the FEV1 ratio in his report. Dr. Blat repeatedly in his deposition, in response to claimants' counsel's attempts to raise this argument, said, no, I do not agree that coal dust exposure does not significantly reduce the FEV1 ratio. So it's really a non-issue. There is no basis to discredit them on the basis of the preamble. I guess secondly, Judge Quattlebaum, I was going to get to your point if that's okay. But yes. I think you're muted, sir.
Sorry. Thank you for pointing that out. Does the preamble say anything about the relative decrease of FEV1 of smoking-induced lung disease compared to coal dust-induced lung disease?
If it does, I'm not aware of it. I mean, the critical point here is that the what the preamble says is that coal mine dust exposure, just like cigarette smoke, does decrease the FEV1 ratio because the ratio, frankly, is a measure of obstruction. I mean, if it reduces at least significantly, you have an obstructive lung disease. Both doctors affirm that it does. I don't see how that is an issue. Judge Quattlebaum, you asked me to address whether you as a court have the authority to review the ALJ's fact findings apart from what the board chose to construe them as. And yes, I believe you do, because the ALJ is the ultimate fact finder in these cases. And as you hinted, it is this court's responsibility to review the agency's fact findings. The board is not the agency. The board is a review body that determines whether the ALJ's decision is consistent with substantial evidence, rationality, and the law. So if you find any one of these the ALJ's justifications for rejecting my company's experts to be flawed, to be not sufficiently explained in his decision, you can reverse, you can remand. Your Honor, I'm out of time. If you have any other questions for me, I'm happy to address them.
Thank you very much. We appreciate the good arguments of counsel. We would normally come down and greet counsel at this point and shake your hand. And as I explained to the prior panel, I don't know if the Zoom technology has afforded that possibility yet. In Star Trek, they say, beam me up. Maybe that'll happen someday. But anyway, we extend our greetings to you and thank you for your arguments. And we'll, of course, take this case under advisement. All right, we'll proceed on to the next case. Yes, Mr. Cagle?
Yes, sir. May it please the court. I'm James McCall Cagle. I'm an attorney in Charleston, West Virginia. In this case, I represent Donald L. Blankenship. Mr. Blankenship was at the time relevant to the charges in this case, the chairman of the board and the CEO of Massey Energy Corporation of Richmond, Virginia, a publicly held company, coal company traded on the New York Stock Exchange. Mr. Blankenship stands convicted of the misdemeanor offense of conspiracy to willfully violate mandatory mine, health, and safety standards, for which he served the maximum penalty of 1 year in prison and paid the maximum fine of $250,000. This case is about multiple violations of Brady versus Maryland and U.S. versus Giglio. The number of violations in this case are frankly startling, as stated by the U.S. District Court when that district court denied the recommendation that the conviction of Mr. Blankenship be vacated. There are several categories that this court has noted, but first I want to mention to you that this case is a weak case, contrary to what the district court said. And I mean weak, the prosecution was of a man who, as CEO, was not in the mine, had not visited the mine during the periods of time that he's convicted of this conspiracy, which indeed is a misdemeanor, not a conviction, that he was acquitted of all felonies charged, and there were 3 in number charged, one of which was a conspiracy, which was a felony, one of the objects of that conspiracy. The verdict was delivered at the end of 36 days, and the trial, virtually 1/3 of which was spent in jury deliberations. The jury returned 2 times, indicated that they were hopelessly deadlocked. The judge obviously gave a instruction to go back and continue, consistent with Allen. The indication from one juror who passed a note to the judge on what I interpret to be the 25th or 26th day of trial, when the last witness was testifying, the note said, "What is Mr. Blankenship charged with?" At that point, it's obvious at least one juror did not know what the charges were. A careful reading of this record would indicate that this trial resembled more a civil case. Indeed, it was prosecuted under a provision of law, 30 USC 820 sub D. That is matters, not criminal matters. As indicated by the record, the defense offered no evidence whatsoever. Mr. Blankenship did not testify. No witnesses were called. They rested at the end of the case, thereby beginning 2 weeks of deliberations. The defense was fairly stated by the gentleman who represented him at trial that Mr. Blankenship is being prosecuted for who he is or what he is, not for what he's done, because the evidence simply was not there. Now, turning to that which is the subject of this, the court has indicated three categories of interest. First, I'll address the 5 witnesses, potential witnesses, who were not called, but were thoroughly interviewed by members of the Department of Justice, by investigators from the Department of Labor, and by FBI agents. There were 5 individuals who delivered information that was absolutely contradictory to the entire indictment and the theory of the case that was presented by the government. Those memoranda of interview were not provided, but they are favorable to the defense. They were contradictory to the evidence. They were impeaching of witnesses, and they were diametrically opposed to the government's theory of the case. And that would involve that he was operating for profits over safety. That was debunked by at least 3 of the 5 witnesses.
Mr. Cagle, Judge Diaz here. I'm sorry to interrupt,
Yes.
but I guess what I'd like to get to is sort of the nub of this case, as I understand it. And if we assume that these witnesses were in fact favorable and might have had material information, the question that arises is whether, in the unique context of this case, where your client is a CEO of a company and these 5 witnesses were all employees at one time or the other of the company, and in fact were on the defense witness list, so obviously there was knowledge of the witnesses, whether your client and his team had a due diligence requirement to figure this out on their own.
Well, they don't. They did not have a due diligence.
But don't our cases say they do? Your
cases wrongfully state that, and I'm
well, that may be, but we're kind of stuck with that.
I think not,
decision.
Your Honor, and let me,
okay.
if you'll indulge me for a
sure,
second.
Go ahead.
I fully anticipated this question. 2 of your decisions would indicate that that's not correct. That this panel can indeed consider that Wilson is bad law after 2004 in the decision of Banks versus Dredge, because Banks v. Dredge rejects the very rationale of U.S. v. Wilson. Those 2 cases are Etheridge versus Northern and Western Railway Company. That's 1993 decision. And Quinn Yin, I'll spell it, Qingyin Lee, Li, versus Eric Holder, Attorney General. That's a 2011 cases. Those cases will say to you, I believe, that you absolutely not only should, but must find that what the district court followed in U.S. v. Wilson is, to put it bluntly, bad law, rejected reasoning by the U.S. Supreme Court 17 years ago. And beyond that, there is no evidence that these attorneys were less than diligent. The court makes a factual finding without conducting an evidentiary hearing that these lawyers were less than diligent. The record in this case would indicate these lawyers were as zealous as lawyers
if that's
representing a defendant could be.
If that's so, wouldn't we suppose that these witnesses were put on the defense witness list, that there had to be a selection process? In other words, you had to know what those witnesses were going to say or prepared to put them on. You didn't put them on. That's a strategic issue. But if they're well-prepared lawyers, wouldn't you expect that before they designate somebody as a witness at trial, they would know, and they at least know the scope of what the persons are going to say?
Your Honor, I would call your attention to that witness list. It is in the sealed part of the joint appendix. That witness list is 4 pages long. It has at the end representatives of Ernst & Young. There is then a supplemental list with 4 more witnesses that says, no, I make that with about 6 more witnesses that has among custodians from Alpha Natural Resources. There is no evidence that they knew what these witnesses. I call that witness a phone book.
Well, you're sort of demeaning your own document. That's a document you submitted to the court and designated witnesses who were going to or could be testifying on your behalf so that you can prepare the other side for recognition of those witnesses and be prepared at trial. It's an information that's provided. So now when you say they over designated, that's okay. But does that mean they weren't careful in their designations?
I'm not saying that. I wasn't a trial counsel, but my interpretation.
But I know that's not an excuse, is it?
Oh, I'm not saying that. No. Okay. What I'm saying to you is there's no evidence that they were interviewed. The judge in the district court. It doesn't
have to be interviewed. Somebody picked those witnesses, which are employees of the company, and they picked those witnesses because they knew about the whole point of Wilson is not only that it imposes on lawyers if it's equally accessible, and those persons are persons to whom you would normally go, and that's exactly what your designation indicates. In other words, you have identified the witnesses that would help your side, maybe not at trial.
My point in this, Your Honor, is that by employing Wilson and saying that under Wilson, you've reflected in that filing that you've interviewed this and know what they're going to say is making a factual conclusion.
I'm not suggesting you knew what they were going to say. I'm going to say you identified them on some criterion, which put them to the forefront, those witnesses, because they were designated to the court by your side. And now you're saying the fact that you didn't interview them and know what they were going to say when Wilson suggests they were equally accessible to you, you should have done that. It's a hard argument to make, isn't it?
No, I think not. I think what you're misreading of not only that filing of a witness list would indicate, A, that they were accessible. Not all witnesses. I've tried hundreds of cases. Not all witnesses will talk to you. You will know of them. Mr. Blankenship had retired from there. Mr. Blankenship personally, by virtue of his bond conditions, couldn't speak to him.
If you know a witness won't talk to you, you put them on your witness list when you're a trial lawyer? I tried cases too. I don't think when I didn't know what the witness was going to say, I'd indicate he was going to be my witness.
I don't. Well, we have a disagreement. What my point
fair enough. You get the benefit on that on this argument. But my only point is these persons were specifically identified by your side. They're not buried in this big public corporation, and you don't know where they are. And so the question is, under Wilson, did you fulfill the duty? Now, I understand your argument that Wilson may overstate the law, but right now, at this point in time, we're bound by that until we reverse it on bank or maybe we find that the Supreme Court reversed it, as you say.
And I'm asking you to do that. Now,
Mr. Cagle, can I follow up on another factual issue? This issue of due diligence, I think, is also part of that analysis. Is the question of knowledge, actual knowledge on the part of the defendant. Does he know the information about which he is complaining about caused a Brady violation? And it seems to me that a lot of these MOIs were discussing either conversations that witnesses had with your client, or let me give you one example. There was a Steve Sears who told investigators that Mr. Blankenship started a safety program for individuals. It would seem to me that Mr. Blankenship would know whether or not he started a safety program for individuals. So why would we find a Brady violation simply because the government failed to produce that kind of information?
Well, because I don't think that's the crux of what was important about the Sears interview. The importance about the Sears interview is that he debunks the profits over safety. issue that was the driving argument of this.
Right, but he debunks it in part because of things that Mr. Blankenship did to debunk that, and or in other instances, conversations that Mr. Blankenship had with other witnesses. It seems to me that it's just in the unique circumstances of this case, you got the CEO who presumably has a relationship with these employees. Why wouldn't he know?
He knows what he knows. I mean, I understand that. I can't argue with you that I know what I know, or that you know what you know. Of course, that's a fair common sense assumption. What I am saying, though, within the context of preparing for this case, I've run out of time, it appears, but in preparing for this case, if I might have your indulgence, please.
Yes.
That Mr. Blankenship's trial attorneys were deprived of knowing what the government had that was favorable that could be used, either in deciding how to try the case, who to call, and how to cross-examine witnesses against Mr. Blankenship. All of that is to the prejudice, and that's what Brady is about.
With Judge Niemeyer's indulgence, I did want to ask you a question about some other components of this Brady claim, and in particular, the claim regarding the agency's imposition of this so-called bad ventilation plan on the company, which the theory goes may have been partially responsible for what happened, the tragic accident that occurred at the plant. So you make this, I think, a fairly compelling argument that that might well have been a defense to any issue with respect to liability. But the problem, as I understand it, I mean, we're here on a habeas petition, is that the district court ruled that none of that was relevant, and that those evidentiary rulings weren't challenged on direct appeal. So, I mean, hasn't the argument effectively been waived by failure to preserve the argument on direct appeal?
Oh, I think not, Judge, and here's why. This information wasn't disclosed. That's the whole threshold problem here. Had this information been disclosed, the trial judge may well not have ruled the way that she ruled. If this information had been available, I submit there were a lot of information that would have been taken into account to consider how one ruled on that trial evidence as presented. It could have been an entirely different case, which was taken away from the defense by virtue of not just failing to turn this over, but in some cases, a conscious decision not to turn this information over, as found by the DOJ in the proceeding against the U.S. attorney and his assistant.
All right. Thank you, Mr. Cagle. You have some rebuttal. We'll hear from Mr. Booth. I think you're muted.
Sorry. Thank you very much, Your Honors. May it please the court. The government's withholding of witness interviews from 5 potential defense witnesses and the MISHA internal documents did not violate Brady. As to the witness interviews, Blankenship could have discovered the substance of those interviews with due diligence, and as the district court specifically held, the information in the MOIs were not material. As to the MISHA documents, the district court correctly held that the evidence of them was either inadmissible or immaterial, and given the standard of review, which is an abuse of discretion, and given the fact that the 2255 judge was the same judge who proceeded a 36-day trial, there was no abuse of discretion in any ruling. And in any event, as the judge also found, most of this evidence would have been cumulative to the evidence that was presented. As to the due diligence requirement, in the Hope case, this court held that the government's failure to disclose witness interviews of potential defense witnesses in the sex crime case didn't violate Brady because the defense could have learned of their existence through a reasonable pretrial investigation. This case is much stronger than Hope for several reasons. First, The interviewees were Blankenship's former mid to high level employees. He knew their positions at Massey. He knew to the extent to which they were involved in the safety measures that he had instituted and how they were implementing them. He had put 4 of the 5 employees on his pretrial witness list, which implies that he had at least made a preliminary determination that they had or could present exculpatory evidence if he had called them. Third, in fact, Blankenship had interviewed Ojeda before trial. And if you look at the substance of that interview in the MOI, that was an extremely intensive interview. Blankenship's attorneys asked her about the Hazard Elimination Committee documents sent to the board of directors, public speeches, whether Blankenship had asked her or anybody else to break the law, and whether he knew of any former Massey employees that were working for another company. Fourth, his general knowledge of their testimony was shown by the extensive references to these witnesses at trial. In his reply brief, Blankenship has indicated that a lot of the information in the interviews was not revealed at trial. Well, we take a contrary view. For example, Blankenship says that with respect to Ojeda, she made statements in her pretrial interview that the privilege markings on the memos were relatively benign, and that contradicted the government's theory of the case that they had a sinister context, that Blankenship used the privilege markings to hide his nefarious schemes from others. Actually, that was covered at trial at length. I would point you to Joint Appendix 1191 to 1194, 2296 to 2298. And here's an excerpt from the closing argument that Blankenship did, and this is on 2656 of the record. Is it really so strange that these memos to Mr. Blankenship were marked attorney-client privilege? They were sent to him by the company lawyer. With respect to Beers,
Mr. Booth, can I interrupt you for a second? And I think I understand the argument with respect to due diligence, particularly given the unique relationship of this defendant to the purported witnesses and material. But Mr. Cagle led off with this sort of foundational argument that he says that circuit upon circuit has simply misread Banks. That Banks has some pretty broad language in it that suggests that it's not. It should not be the case that prosecutors can lie and conceal, and the defendant has the burden then to discover the evidence. And I get the point that we have this history of precedent that suggests otherwise, but why isn't that why can't Banks be fairly read to reject this kind of, the prosecution hides and the defendant must seek?
Let me state there's 2 things about the Banks decision that I would like to emphasize to you. Yes, Banks did say that defense attorneys don't have to scavenge for hints of Brady material if the prosecutors tell them they're learning. But it's important to look at the facts of the case in Banks and what was the type of evidence that was withheld. One of it had to do with witness prep, and another one had to do with information given about an informant. This is information that typically is either in the exclusive or near exclusive control of the prosecutor. And if that's the type of evidence that we're talking about, including also the evidence in the Third Circuit case and the Fifth Circuit case, a lab report and a receipt, then yes, a defendant should not have to go and try to scope out and find out where that evidence is. But where this is evidence that's freely available to both sides, where both sides have access to the evidence and get to it, then our submission is that Brady does not do away with the due diligence requirement, or at least this court fairly applies the due diligence requirement in that scenario. Again, neither Banks, neither Dennis, the Third Circuit case, or Vanoy, the Fifth Circuit case, involved evidence that was freely available to both sides. In the case where the evidence is not only freely available to both sides, where the defendant puts 4 or 5 of these people on his witness list, interviews one of them extensively before trial, and then says, by the way, the reason he didn't call any witnesses in his own case was, and this is at page 2626 of the joint appendix. I told you in opening it may take us a while to put on evidence. It indicated Massey did not want citations. I didn't realize that we were going to do it with the government's key witness. So my suggestion to you is twofold, Judge Diaz. One is that neither Banks nor the cases that have pretty much limited the due diligence exception don't involve this scenario. And even if at some particular point this court were to think about it, it would have to take the en-banc court to do it, because this court has repeatedly said it, more recently in the Zook case, which is in 2018. But we understand the situation in which evidence which is not readily available to the defendant is one in which we really can't fault the defendant for not having gotten it. But this
well, it's no less a Brady violation in this case, right? Because the prosecutor suffered consequences as a result of not disclosing it. I guess you're saying that in terms of the effect and the prejudice, there is none because of the fact that the defendant had equal access to the information.
Well, your first question was there was a Brady violation. No, we do not believe there was a Brady violation in this case, because there was not an improper withholding, because this evidence could have been discovered by the defendant. We agree, of course, as OPR found, that there was a violation of the government's internal discovery procedures, which are much broader than the due process clause of the Fifth Amendment.
Fair
but
enough.
Again, your foundational question is whether you want to eliminate the due diligence requirement is one for the en-banc court, not for this panel. And again, we would distinguish the situation where the evidence is freely available to both sides. If I could go back,
Counsel, if I could pick up on the last thing you said, I don't think you take the position that the MSHA documents were available to the defendant. And in particular, I'd like to discuss the bias documents. Those don't seem to be the subject of admissibility decisions by the district court. The argument I think that the district court made was that, well, they don't necessarily reflect the whole agency's view, and there was they were cumulative, and I think the third reason was, well, there was other evidence that to justify the conviction beside this. But those are some pretty strong language in those documents. And, I'd really like to hear your response on that. I don't see how to say they're cumulative seems difficult. I know there's testimony about a strained relationship, but, the expletives and the graphic language, if we were to consider this, comments made by police about a potential criminal defendant, it would be I would think it would be a challenging case. Why don't the bias documents alone, even if you're right on the other issues, cause you a problem under Brady?
Because it's our position here, as the district court implicitly found, that the evidence that several MSHA employees, right after the explosion, which, by the way, the party stipulated was not an issue in this case, these comments occurred after the explosion. Yes, these employees made some rather insulting statements about Blankenship. There's no rule of evidence that permits this type of comments to be admitted into evidence under the rules. This is not a case where a witness is biased. This is not a case where a charging decision has been accused of bias, where the U.S. attorney, for example, may have based his charging decision on race or religion. These are comments made by mid-level or higher-level employees in the federal government, casting aspersions on the defendant, primarily because they felt he was responsible for the mine explosion. That's not admissible. And as the district court indicated, that certainly isn't indicative of agency bias. Again, the agency bias question, which Blankenship skillfully brought out at trial, was really all he was entitled to. And he brought that out over and over again. It was in his statement.
Sure, but yeah.
But again, the bias, this is not legally relevant bias. Witness bias, for example, that's different. If a witness comes in and he's biased, sure, under Abel and a number of Supreme Court cases, that is admissible. And if that had been withheld, that would be relevant. But just an employee in the federal government making a vulgar comment about a soon-to-be defendant, that's not in. There's no case cited by Blankenship in his brief that said this is admissible evidence. And the district court was absolutely correct in so holding. Again, and we think that to the extent that there was bias in terms of the contentious relationship between Massey, Blankenship, and Misha, thoroughly revealed at trial, wouldn't have made it.
So what, I realize that issue was addressed, but obviously I would think the defendant would, have been able to address it with greater force, or at least would have attempted to had they had these documents. Now, your position is that those would not have been admissible, and I guess we don't have a ruling on that because they weren't disclosed and it wasn't addressed. And you may be, this may be unfair. You said that the defendant didn't cite a case that said they were admissible. Do you have a authority on facts like these with, it's not just a random federal government employee, it's 5 or 6 things, related to safety where that was deemed inadmissible on the question of agency bias? And maybe it is. I'm not suggesting you're wrong, but if you have a case, I'd like to look at that.
I don't have a case specific. Again, the district court indicated that it was very skeptical that this was evidence of agency bias. He pointed out, for example, that at one point, one of the supervisors had disagreed with one of the comments made in one of the meetings. I am saying there is little doubt that agency bias, again, with respect to perhaps a charging decision, would be admissible at trial. But there's nothing that we have found in the federal rules that would indicate that a federal government employee's hostile remarks about a defendant after the explosion, remember, Judge Quattlebaum, virtually all of the statements made in these Misha materials were made after the explosion in this case. And remember, again, I hate to belabor the point, the district court, the parties agreed that the causes of the explosion were not part of this case. And that's why the court emphasized that and whether Misha's disciplinary actions and the cause of the explosion and all that was not admissible. And the only question before you was that an abuse of discretion by a district court judge that had sat through the whole 36-day trial and would be in the best position to decide whether or not a piece of evidence is withheld would have been admissible under the rules. And remember, under the Supreme Court's decision in Wood, if it's not admissible evidence, it doesn't violate Brady. Now, there is some courts of appeals have said, well, if it could have led to admissible evidence, this court hasn't bought that exception, that it might be. But there's nothing in this record to show that that would have led to admissible evidence. What you have here again, you have employees who are casting aspersions on a defendant after a mine accident that killed 29 people. Calling, there's a scatological. I'll go, Judge Quattlebaum, I'm sorry. Go ahead.
Yeah, you mentioned that this is an abuse of discretion standard of review for us, and I mean I think that's certainly evidentiary rulings. I know we review for abuse of discretion. Why do you say the decision about whether I'll just pick the bias one since we've been talking about that. Where a Brady violation is an abuse of discretion. What says that?
I'm sorry, Judge Quall, I didn't mean to interrupt you. Go ahead, finish, please.
No, I think you were getting to my point. I'm trying to figure out, I mean, the district court's evidentiary rulings are abuse of discretion, but the claim that these are a Brady violation, is that abuse of discretion review?
No, Judge Quattlebaum, it is not. The Brady violation is de novo. However, under Brady, under the Supreme Court's decision in Wood, inadmissible evidence is not material under Brady.
Sure. No, understand that point.
Inadmissible, right. So if the district court has held that all of this Misha material, pretty much all of it, he had slightly different rationale for each, was inadmissible evidence, all you do is make a determination as to whether there was an abuse of discretion on the part of the district court in making that admissibility determination. If you were
but on the bias evidence, that wasn't part of the rationale of the district court.
Since you've asked about it, Judge Quattlebaum, I think I probably need to read what the district court said.
Yeah, and I could be wrong, but I thought the reasons were it was cumulative, it was not the agency's position, and there was other evidence beside it that, you know, that would have justified the conviction.
Well, for example, on the joint appendix 46, the court says emails tending to show bias on behalf of individual MSHA employees does not necessarily substantiate a claim that the agency itself was biased against the movement or massing. In fact, as the movement that is Blankenship below, the sentiment expressed in at least one of these two emails was directly overruled by the head of Misha. This supports the notion that decisions made on behalf of the agency were not impacted by bias held by individual Misha employees. And that's on page 46.
Yeah, I'm familiar with that. I agree with.
Right. The court is effectively saying here that you may have expressions of hostility or anger, scatological references by some Misha employees towards Blankenship. That doesn't amount to a agency bias. Agency bias would stand on a different footing than a stray comment, one employee, 5 employees. That's inadmissible evidence. There's another comment or two earlier on in the opinion, but it's pretty obvious that the district court did not make any finding of agency bias in this case. Well, again, you had scatological references, that's all.
Mr. Booth, Mr. Cagle led his argument with a sort of the background of the prosecution of his client, the fact that, as he put it, that he was prosecuted not for what he did, but for who he was, the fact that this was a closed case, the jury was out for a couple of weeks, apparently. The judge had to give 2 separate Allen charges. And I think maybe the argument is that somehow factors into this issue of whether or not we should find a Brady violation in a close case. Is there any authority for that proposition?
No, there isn't. What is important is whether or not the evidence that was withheld would have caused a reasonable probability that the outcome would have been different. That's what the Brady test is. Whether or not the jury was out for a certain period of time, whether the trial was 36 days, whether there was an Allen instruction, are really factors that do not bear on the issue. For all we know, the jury may have been hung up on the 2 felony charges that they ultimately acquitted Mr. Blankenship on. And in a 36-day trial involving a technical defense involving whether there was a willful violation of the statute, it's not necessarily unusual that the jury may have had some questions about it. But the only question that you have to decide is whether or not the omitted materials, assuming they're admissible, if they're inadmissible, that's a different matter, would have created the reasonable probability of a different result. And that's the only question we submit that you have, and we submit the district court found that didn't happen. There was no reasonable probability. Again, if you look at the defense in this case, Blankenship did a very, very targeted and specific defense. And that's why he said, for example, at the end, I didn't have to put on any witnesses. He knew exactly where he was going. He knew exactly when he had Blanchard, the government's main witness, testify at the end of the cross-examination. I wasn't involved in a conspiracy. He presented a very, very specific defense based on all the information he had, and all that information was given to him by Blankenship because he knew what was important to show the safety measures he took. and why he tried to reduce citations. None of this other things, including the MSHA. I'm sorry, am I out of time? I just don't have
Yes,
time.
you are. And you
I'm
can
sorry,
wind
I
up.
just don't
That's all
see
right.
it here. I'm
Okay.
sorry, let me hang up. I would ask you to affirm the judgment. If you have any further questions, I'll be happy to answer them.
Thank you.
Thank
Mr.
you very
Cagle.
much. Let me
Yeah.
unmute myself.
Mr. Cagle?
Yes, sir. Thank you. I want to address the question that was recently asked about the authority. There are two cases that mention the weakness of a case as being relevant to determination of a Brady violation. Both were cited by the government in their brief. One is Weary versus Kane, a U.S. Supreme Court case of 2016. The other is the Bartco case, which was a Fourth Circuit case decided in 2013. Each of them considered the weakness of the case because it says when considering the context of all the evidence, it is important to determine the effect of that on the ruling of Brady or not on what you withheld. That's the determination of why a withheld piece of evidence is material or not, because it would have prejudiced a person. It prejudices a person more in the context of, excuse me, I'm losing my voice, in the context of a weak case. And that's why I made that argument. Now, as to the MSHA materials, they are frankly shocking in what they said, and they are not coming just from the Mount Hope MSHA that was addressing the UBB mine. And they come from the highest levels of MSHA in Arlington, Virginia. The one of them comes from the person who was charged with the duty of determining how death cases would be handled. And I point out to you, they say, well, it was after the explosion, but it was before the indictment. And that's why that information was important. It could have been used. It would have been relevant under Rule 401. It's a relevancy issue, whether or not it makes a fact in dispute of consequence more or less probable. Those are standard information that is supposed to be delivered under Brady. When the judge ruled on what is relevant or what was going to be admitted in MSHA, she didn't have that information. That's one of the ways that Mr. Blankenship and his defense was prejudiced in this case. It's not just that he could have called 5 witnesses that he may or may not have been able to interview, which I still say is a question of fact. But but it is what would the quality of his defense have been had he had it. His lawyer was among the most skillful cross-examiners in this country. What might he have done with that scatological information about Mr. Blankenship, which occurred before the decision was made and charged him with the nebulous notion that he was never accused of advanced warning? He was prosecuted on things nobody else was ever accused of, ever, and charged with knowledge of things that happened deep inside a mind when he's sitting as chairman of the board and CEO. Now, those are the violations that they try to put on him, but they are not consistent with what MSHA documents say they even believe to be a violation or even understand to be a violation. The MSHA material and its failure to disclose is among the most critical in this case. It is equal to the withholding of the information from the 5 witnesses who used to be under his employment. And I will tell you again that he could not have interviewed him. He could not have spoken to him, and it would have been a violation of his bond condition. The matter of the the judge's ruling about MSHA and about causation, it really was a stipulation that we're not going to try this case on causation. But I point out to you, had that information been available, including the concern expressed by MSHA itself that our report indicates we may be responsible. And indeed, my client thinks they were responsible because of the ventilation plan. Had she had that material, the rulings on the evidence would have been different. I'm out of time, Your Honor.
Thank you. Yes, Mr. Cagle. Thank you very much for your argument. Mr. Booth, for your argument. Our practice, as you know, is to come down and greet counsel, and the best we can do is extend our greetings here today, but I know you'll both be before us again, both of you. I think, Mr. Cagle, you've been before several times, haven't you?
I have, yes, sir. I have.
Yes.
I'm old. If your point is I'm old, I'm old.
We'll see you more, I'm sure.
Okay.
Anyway,
All
it's
right,
good
you
to hear
take
from
care.
you both, and we appreciate having your arguments.
Okay.
With that, we'll adjourn court till this afternoon.
Thank you.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
All right.